Hello and welcome to the Rodgers Brief. I'm Adam Rodgers. Thank you for watching and thank you for listening. This is, I think, video 9 in my continuing series on deficits of trust, which is my ebook report on the events of the mass shooting in Nova Scotia of April 18th, 19th, 2020, and the Mass Casualty Commission, which examined those events. So I'm here on part 3. And this is called Traumatically, Misinformed, the Nova Scotia Mass Casualty Commission. And today I'm going to start reading from the section that's entitled Pausing Before Starting, Delay for Narrative Formation. And I'll read a few sections. It will probably be 2 or 3 more videos, and that will complete the ebook as an audio book of sorts. You can, if you're watching this on YouTube, you can also get this as a podcast on Apple or Spotify podcasts. Just look for the Rodgers Brief, or vice versa. If you're listening to this, you could also be watching the video as well. So, pausing before starting, delay for narrative formation. The MCC hearings were set to begin in late October 2021. Not coincidentally, the commanding officer of the RCMP in Nova Scotia, Assistant Commissioner Lee Bergerman, announced that she would be retiring from the force in early October 2021. It is easy to lose count of the high-ranking RCMP officers involved in the events of the mass casualty who have since retired, but she is the most prominent of them. As I will come back to discussing, the RCMP now claims to view this in a positive manner. The thinking being that now it will be easier to make a fresh start and rebuild trust with both the public and with other police forces in Nova Scotia. The proceedings did not end up starting until January 22, 2022. This initial delay was explained by the commissioners as being a good thing, as it would give the participants more time to meet and spend their time creating foundational documents, which would shorten the hearing portion of the MCC proceedings. The process of creating these documents was a unique feature of this commission compared to other inquiries. It is a feature which has some appeal, but also some areas of concern. The potential good that such meetings might produce is to act as a discovery would in a civil suit, or perhaps a preliminary hearing in a criminal court context. Before trial in a civil suit, a discovery is a chance to interview the other party or key witnesses on the record, with full disclosure having already been made. The rules of evidence are relaxed in terms of what might be a relevant question, so you can ask questions on just about any topic touching on the issue at hand, and by doing so hope to discover what really matters. The discovery process also allows you to focus your questions at trial on the key areas of dispute, rather than exploring lines of questions during precious trial time that may not end up yielding significant insight. A key distinction between the MCC foundational document creation process and a discovery or preliminary hearing was the absence of any actual witnesses in the meetings. In a regular criminal or civil case, one of the things a lawyer is trying to evaluate is the witness themselves, looking for signs of credibility shortcomings or any significant reactions to being challenged by contradictory testimony or reports. That key element is hard to evaluate from only a written report. Broadly speaking, the risk was that this foundational document exercise would become a narrative formation process that is so controlled that the hearings then take on too much of the character of a PowerPoint presentation rather than a court hearing, where facts and narratives can be effectively challenged. Efficiency is a worthy objective, but not at the cost of getting answers. Marginalization of MCC participants. Patterson Law, the firm representing many of the families who lost loved ones during the shootings of April 18th, 19th, 2020, issued a statement during these meetings calling for the Mass Casualty Commission to commit to a start date and suggesting as well that there was a lack of clarity as to how the MCC hearings would operate. Most significantly, these lawyers, who were the main non-governmental participants, still did not know at that late stage of preparation whether they will be able to cross-examine witnesses during the MCC. This was very troubling news and did not bode well for what was to come. The Commission's spokesperson responded to that point by saying, "Any additional questions participants may have will be addressed through the course of the proceedings." That could be read two ways. The straightforward way would simply be that if parties feel they have questions after any witness is examined during the hearings by Commission and Legal Counsel, they would be permitted to cross-examine that witness within the usual boundaries of relevancy. A more restrictive interpretation would suggest that the Commission felt they had already given each party a sufficient chance to ask questions during the closed-door sessions, and therefore any request for additional questions during the actual hearing might be met with resistance. We now know that the more restrictive approach was the one adopted by the commissioners. We may wonder why Patterson would participate in the secretive foundational documents formation process without knowing that answer. Their statements suggested they were wondering that themselves. It appears that they did so reluctantly as something of a show of good faith in the process. Their good faith would be tested many times during the 75 days of proceedings. The MCC spokesperson made a point of stating in an interview with Global News that there are 61 parties involved in the proceedings, as though to say or subtly suggest that it would be practically impossible for each of the parties to cross-examine each witness. The implication we were supposed to take from that was that therefore we should have abandoned thoughts of any court-like cross-examination taking place. That was an untenable position, and one that dramatically overstated the complications of allowing cross-examination. Though there may have been 61 parties, most in fact had limited participation rights, meaning most would not have had the expectation or right to cross-examine, but would instead submit briefs, reports, or participate in panel discussions. The commissioners had already stated in their participation decision how some participants would have limited rights. Victim advocacy, health-related, and firearms groups were all limited to participating in roundtables and assisting with expert reports to the Commission. The police organizations were limited to issues relating to the policing aspects of the inquiry. It was never going to be the case that all 61 parties would be lined up to examine any one witness. It was supposed to be the responsibility of the commissioners to use their discretion to determine when each party would be entitled to cross-examine each witness, based on their interests and the potential benefit to the overall understanding of the evidence by having them participate. In the Desmond inquiry, the process for most witnesses had been to have inquiry counsel lead them through their evidence, and then for the other parties to examine each in order. Judge Zimmer comes from the provincial court and has followed the practice in that court of having the federal government lawyers go first in cross-examination, followed by the provincial government lawyers, and then each of the other 5 to 7 parties. Not all parties appeared every day. Examine the witness in order of the seniority at the bar of the lawyer for that party. This worked well. I was usually one of the last lawyers to ask questions, and if topics had been covered already, I skipped those questions I had prepared. Also, for most witnesses, like they did at the MCC, the provincial government did not ask any questions, though they have had 2 lawyers present at all times. And it was not unusual for the federal government and the health authority lawyers to not have questions either. Judge Zimmer would often ask questions after each lawyer had a chance, and sometimes inquiry counsel had follow-up questions. For witnesses proposed or presented by any of the parties, that party led the witness through their evidence, and then inquiry counsel went next, and the order continued as usual after that. This is all in line with how inquiries are supposed to proceed. According to the leading law text in Canada on inquiries, The Conduct of Public Inquiries by Professor Ed Ratushny from Ottawa University. For witnesses proposed or presented, there are many elements of an inquiry that are distinct from a regular criminal or civil trial, but cross-examination of witnesses is one element that almost always remains a constant. Cross-examination forms part of the bedrock of our system of justice and is widely acknowledged to be the most effective manner of shedding light in dark corners and poking holes through contrived narratives. If the main non-governmental parties cannot cross-examine witnesses, a process cannot be considered a true public inquiry. The Mass Casualty Commission issued an update on January 31, 2022, about a month before proceedings started. In the update, They discussed the upcoming proceedings, the role of participants, forthcoming reports, and forms of engagement. In my view, the real purpose of the update, however, was to manage, that is, lower, expectations as to what would likely take place during the proceedings. The release noted that family members have been urging the commissioners to begin proceedings quickly, while other, unnamed, participants had been asking for more time. The suggestion from this duality seems to be that the commission was attempting to reach some kind of balance in the demands of the various participants. Certainly, it seemed to be in the interests of the RCMP to continue delaying the beginning of proceedings as a way to diminish public interest in the activities of the Commission. The commissioners, however, did not seem to be aware of such dynamics among the participants. There were some comments in the release regarding where people would be able to watch. There was to be a live stream with video archive for those not able to watch the proceedings during the day. In addition, for the families, there would be viewing space in Truro, as well as at the Halifax Convention Centre, outside of the hearing room itself. The main section of the release, however, dealt with the role of various participants. The Commission noted that the, quote, role of participants, close quote, section of their website had been updated, but significantly, there was still no direct statement on whether parties would be entitled to cross-examine witnesses during the proceedings. The Commission has a very large staff, so we could usually presume that the words in any release were chosen carefully. In this case, the failure to answer the question about cross-examination seemed to be a deliberate choice. The statement by the Commission pointed to the rules of procedure that had been adopted by the Commission. They noted that participants were entitled to suggest witnesses to the Commission and also to suggest line of questioning for particular witnesses. I have never heard of such a technique of examination being used in any setting, and cannot imagine a situation where giving a line of questioning to another lawyer to ask, rather than asking it yourself, could be effective in achieving whatever goals you hope to achieve from that line of questioning. The Commission undermined that limited input further by stating that ultimately the foundational documents were the Commission's documents and, quote, share the results of the Commission's investigation. Note that it did not describe the results as preliminary or partial, but the results, suggesting that no further probing or questioning would be needed or would take place. The rules certainly do allow for participants to examine witnesses and to cross-examine witnesses. Rule 51 notes that Commission Counsel has the right to re-examine any witness at the conclusion of their evidence, which may seem to imply that there must have been cross-examination at some stage. In a usual criminal or civil trial, you have direct examination followed by cross-examination, and then the lawyer who did the direct examination has an opportunity to conduct re-examination, but only on topics raised during cross. Rule 52 follows that up by saying that participants may have an opportunity to question the witnesses. This means the commissioners would decide in each case whether a participant may ask questions of a particular witness. The only guiding language used in the rules to tell us how that might turn out is that the right to question witnesses was limited by the extent of their interests as determined by the commissioners. That was very vague language with wide discretion for the commissioners. They would later point to those rules when they were critiqued for not allowing cross-examination, saying that no parties objected to the rules when they had the chance. As I predicted at the time, the real purpose behind that statement appears to have been to soften the blow for when proceedings started, and instead of witnesses telling us what they did and saw and being challenged on cross-examination, we were presented only with an MCC lawyer reading in the evidence, or some form of prepackaged question and answer session between Commission Counsel and representative witnesses. Such an outcome fell far below what I sensed the public's expectations of this commission had been when it was established, and represented a further disappointment to those who invested their time and energy in this important cause. After 2 delays and nearly 2 years after the tragic events, the Mass Casualty Commission began public proceedings on Tuesday, February 22nd, 2022. There was considerable anticipation and more than a little consternation as the opening moments approached. The first day featured opening remarks from the commissioners, followed by a panel on mental health and wellness. The stated goal of this panel was to normalize and validate emotions that people involved may be experiencing and to help people prepare for what was to come. It is noteworthy that there was not an opportunity for any of the other parties involved to give opening statements. In other inquiries, that has been the case, and such statements can be valuable ways for those watching to get a sense of who is involved and what the important issues will be, rather than just those of the government-appointed commissioners. To have the participants sidelined at the very beginning like this did not bode well. Early outlook from the MCC and police intelligence questions. After months of delay, the Mass Casualty Commission finally began their public proceedings. The commissioners and parties were in Halifax at the new Nova Centre, while some family members watched from a viewing site in Truro. I was watching the live stream, which featured ASL translators, closed captioning, and French-English translation services. For the first hour of the Mass Casualty Commission proceedings, the commissioners took turns making opening remarks. Then there was a 2.5-hour break before the 2 afternoon panel presentations. It was clear from the opening remarks that the commissioners were conscious of some of the public criticism that had emerged, most prominently in the weeks immediately prior to the start of proceedings. They used much of their introductory remarks to sell the intended inquiry process, and Commissioner Kim Stanton specifically made a point of noting that her newly released inquiries book was written before the MCC was established. Commissioner Michael MacDonald, who is the former Chief Justice of Nova Scotia, but was referred to here only as Commissioner MacDonald and was not wearing judicial robes nor appearing in an official judicial capacity, put his judicial reputation on the line in a sense, using his remarks to stress his commitment to independence from government and police. On the important question of whether witnesses might be called, Commissioner MacDonald said they will be called if needed, and suggested the possibility of robust cross-examination. This scenario was presented by him as a last resort option, to be used if other processes, such as witness interviews and discussions among the parties, failed to otherwise elicit the true facts. On the foundational documents, Commissioner MacDonald indicated that the participants had a significant role in their formation, or at least the opportunity to contribute to their formation. That was somewhat difficult to square with the then recent criticism from the parties that they did not feel they have a good sense of what is going to happen during the MCC proceedings. Rather than starting with witnesses who had experienced the shootings or officers who had investigated them, the early days of the proceedings featured presentations by MCC lawyers that were meant to consolidate details of what was known by all witnesses about what really happened. As we listened to the Mass Casualty Commission lawyers present their version of key early events through audiovisual PowerPoint presentations, something was missing. The question of motive or any evidence that might reveal Wortman's potential motives was not being interwoven with Commission lawyers' attempts at factual narratives of what had happened. In a way, not having this element of the individual scenarios included could have detracted from the overall narrative of the mass casualty, making it seem like we were only getting part of the story. From media reporting, we knew that in many of the fatalities there was some connection between the killer and his victims that seems to align with theories on possible motives he may have had. The Commission made a deliberate choice to separate what happened from why any of it may have happened. This separation served a legitimate purpose, in the sense that it allowed us for a time to focus on the police response somewhat in isolation. If we did not yet know too much about the perpetrator involved, it gave us a better imaginative access to what we think a reasonable police response should have been, both for individual officers and collectively as a force. When reviewing the police response to the active shooter situation, the question of Whether there may have been any motive might matter very little. In such a scenario, the primary responsibility of the police is to stop the active shooter, regardless of whatever their motives may be. Certainly, if the motive is obvious and clear to the police, there is a chance that knowing it may help predict the actions of the perpetrator. Such clear predictability would seem to be a rare happening, however, and so police need to be trained and ready to confront an active shooter where little is known about the individual. So, in the relatively narrow terms of the police response, questions of motive are less relevant. In another sense, however, motive is very important, and a discussion of Wortman's motives could serve as a reminder of the other policing issue Commission must address, that being police intelligence. In the Mass Casualty Commission Orders in Council, related issues that the MCC was planning to examine in Phase 2 are listed. Phase 2 is when the Commission intended to explore related issues, such as communication between and within agencies and services, as well as Wortman's interactions and relationships with police and social services. When it comes to communication between and within agencies and services, those agencies and services included are the RCMP, Municipal Police, Canadian Border Services, the Criminal Intelligence Service of Nova Scotia, the Canadian Firearms Program, and Alert Ready. It seemed to me at the time as though the agency at the center of this discussion would be the Criminal Intelligence Service. This is a special policing entity in Nova Scotia that is tasked with fighting organized crime and managing the exchange of information among police agencies. It is made up of officers from the RCMP as well as municipal forces throughout Nova Scotia. As it turned out, however, very little time was spent by the MCC looking at the Criminal Intelligence Service. The only time it was raised was with respect to the bulletin on Wortman that was placed in a file and never reviewed again until after the shootings. The RCMP had been warned from very credible sources in 2013 of Wortman's history of domestic violence and complaints regarding unlicensed firearms. Prior to that, in 2011, the Criminal Intelligence Service received an officer safety bulletin regarding Wortman, saying he was in a mental health crisis, had guns, and wanted to kill police. We know that the RCMP have concerns about revealing intelligence methods and capabilities, and that they have shown great reluctance to disclose such information to date through the ITO process. There was no reason to expect that approach to change during the MCC. What seemed to be emerging, however, was that there was very little police intelligence activity taking place to reveal or conceal. So, while the MCC was initially focused on one aspect of policing in Nova Scotia, the response to an active shooter situation, there seemed to be still more and different aspects to review as the proceedings moved along. While the lack of discussion on any motive the killer may have had perhaps detracted from the public having a full understanding of the mass casualty narrative in those initial weeks, that limit on detail seemed to have been a deliberate choice which at an early stage was a useful one to allow. A fulsome discussion on the killer's motives was to take place in Phase 2. In that discussion, we were led to expect there would be an examination of the detective work involved in police intelligence in Nova Scotia, which was to allow us to imagine ways to modernize our approach. As it turned out, the MCC essentially threw up its hands and decided it could not figure out Wortman's motives and left it at that. The lack of a clearly identified motive for the killings and the failure of the MCC to construct a plausible narrative that fit with Wortman's psychological profile, which they would not let the public see, has been a failing of the MCC and has led to an idea that still persists that Wortman had some police connections that the RCMP are just not ever going to admit. In criminal investigations and trials, it is not uncommon to see the involvement of confidential informants or police agents. Confidential informants in particular are commonly used as sources of information that can lead to search warrants being obtained by police for drug trafficking allegations. Police agents are most commonly used in organized crime investigations. Though any linkage has been denied, there are some lingering facts which are still causing reasonable people to wonder whether Wortman had some relationship with the police as either an informant or an agent. He had a history of cross-border weapons and drug smuggling. His friend that made the RCMP decals for him, Peter Griffin, has been linked with a Mexican drug cartel. While the killing spree was still ongoing, this same friend was evacuated from his home by the RCMP before children who were hiding in Lisa McCulley's basement were rescued. The RCMP called in other RCMP units rather than close by municipal forces. Previous complaints to the RCMP about guns and domestic violence were seemingly ignored. In addition, Wortman withdrew a large amount of cash from a Brinks depot weeks prior to the shootings in a manner that has been described as how undercover operators might behave. That has all led some to speculate that he may indeed be an agent or informant, and that the police are just not telling us. If that was the case, the question became whether we would be able to find it out during the MCC hearings, or whether there was something that would allow the state to keep that a secret. The answer was that yes, we should have been allowed to find out. First, there is an important distinction between being a confidential informant and a police agent. The difference between being an agent or an informant is whether you have taken direction from the police in obtaining the information you are providing. Someone who buys drugs and then tells police is an informant, while someone who plans a drug buy with police assistance is an agent. The difference is important, as there are different protections provided by the courts depending on which label is applicable. This dynamic usually plays out in the context of a criminal trial, and the legal framework that is developed around the question is not entirely well suited for an inquiry scenario. Confidential informants are most often used in criminal investigations to justify search warrants being issued. Their information can be relied upon to grant search warrants if it is compelling, credible, and corroborated by police investigation. Credibility is difficult to assess, but if the source has provided information on other occasions that has led to arrests and convictions, they are more likely to be seen as reliable. The Supreme Court of Canada has said that informer privilege is near absolute. So, publicly identifying a confidential informant is effectively prohibited. The only exception is a narrow one. If the accused person's innocence is at stake and there is no other option but to reveal the source, then the person's identity can be revealed. In practice, however, whenever that point is reached, the Crown will withdraw or stay the charges rather than reveal the name. This informer privilege even continues after someone is dead. The logic behind that is that it will protect family and friends of the informant, and also that it encourages people to come forth by keeping privilege near absolute. There has been American jurisprudence to say that this is limited where there is no longer any danger to anyone who might be exposed, but that has not yet been adopted in Canada. Certainly, though, in the context of an inquiry like the MCC, I would expect that an exercise in balancing the benefits and potential harms of revealing the gunman as an informant would favor publicizing the fact that he was an informant. An inquiry context certainly changes some parts of the equation. British Lord Justice Salmon has stated that it is of the greatest importance that hearings before a tribunal of inquiry should be held in public. It is only when the public is present that the public will have complete confidence that everything possible has been done for the purpose of arriving at the truth. Calling off the MCC because someone was an informant would certainly not have been justifiable. So there would have needed to be another approach taken, one that provided protection for sources, but also allows the hearings to continue. Previous federal inquiries provide some insight into how that might be addressed. One option that has been used is a partial publication ban, which is often used for children, victims of sexual abuse, sensitive financial information, or to preserve the right to a fair trial. Another option is limited use of in-camera hearings. In the Air India inquiry and also in the Mahar Arar inquiry, national security concerns issues had to be addressed by the commissioners. In the Arar inquiry, Commissioner O'Connor held in-camera hearings, after which he issued reports that could be released publicly. The federal government at the time was so worried about what would be revealed that they even applied to court to have these summary documents amended to remove information. Commissioner O'Connor indicated that this issue was a struggle, made worse by the fact that the government overclaimed national security confidentiality. We have already seen similar government overreach issues in the process to review the search warrant documents in this case. Even though these documents are supposed to be public by default, media organizations have had to go to court to have redacted portions of documents disclosed. We saw the same only if we have to approach from the federal government during the MCC hearings. Ultimately, however, if Wortman were an informant, we should have been told. The MCC could have initially held some in-camera hearings to determine who, if anyone, might be at risk should that status become public knowledge, and whether there are steps that should be taken to protect those people. Then, once those protections were in place, the evidence could have been heard. If, rather than an informant, he was a police agent, we should have heard all about it during the MCC hearings. An agent is someone who acts on direction from the police, and their identity is disclosable, according to our Supreme Court. Criminal trials are again where this normally arises, and the distinction between an agent and an informant is taken from the perspective of the defendant. If the defendant confesses to a crime to someone, who then tells that to the police, the accused's charter rights, particularly the right to silence, is not engaged in the same way as it would be if the police sent someone in with a recording device and a plan to extract a confession. In such a matter, it would be important for the defendant to know whether the witness was a police agent. If the MCC wanted the public's complete confidence, this all should have been either revealed or else dismissed in a manner that gave the public confidence that there are other compelling explanations for the series of emerging facts that suggest a connection between Wortman and the police. The only attempt to do so by the MCC was a 7-page report by Toronto Police Service member Stephen Henkel. Mr. Henkel concludes that no reasonable person would think Wortman was a police informant or agent. He bases this conclusion on 3 things. First, that the large cash withdrawal Wortman made just prior to the shootings, which was suspected of being informant-like in character, actually had a trail of emails leading up to it between Wortman and CIBC officials, which showed that the $475,000 was all Wortman's money. Second, Wortman, according to Ms. Banfield, did not have a cell phone, which would have made it very difficult for police to get in touch with him. Thirdly, the police denied it. This cursory review of circumstantial evidence is not the thorough investigation that the public expected from the MCC, and certainly not sufficient to end the questioning. Okay, I'm going to cut it off there for today. Thanks for everybody. I'm going to come back in a few days with the next section, which begins with disorienting and not at all trauma-informed approach to evidence. So thanks for listening to this section or watching this section of Deficits of Trust, my ebook report on the Mass Casualty Commission. If you like what you're watching and hearing, please like, subscribe, share it so others can see it as well. And otherwise, thanks for watching, thanks for listening, and we'll see you next time.